everyone, welcome to iExamBee. I'm Neha, your law faculty at iExamBee. In this video, I'll be continuing ahead with our mock test series discussion. However, इस वीडियो में मैं आज स्टार्ट करने वाली हूँ एक new legal subject that is the Companies Act. Do remember to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. You can even reach to us through this email ID or you can call us on this particular number if you have any questions or queries. And apart from this, do remember to visit our website wherein you will get details with respect to various competitive exams. So do remember to subscribe to the channel, stay tuned and stay updated. So जैसा कि मैंने आपको बताया कि इस particular वीडियो में और आगे की वीडियोस में मैं डिस्कस करने वाली हूँ various mock tests related to the Companies Act. And so in this particular video under the Companies Act, I'll be discussing about the incorporation of a company. So Companies Act, first and foremost important chapter if we talk about is the incorporation of a company, which is basically talking about all the basic requirements or compliances with respect to going ahead and forming or incorporating a company. So incorporation is basically dealing with all those aspects. So moving ahead with our very first question, that is, a company limited by shares is a type of company where the liability of its members is. So basically we know that there are various types of companies. Types of companies होती है membership के basis पे, liability के basis पे, control के basis पे. So इस particular question में पूछा जा रहा है कि एक company जो कि limited by shares है and it is also mentioning it is a type of company. So it is a company wherein the liability of its members is what? So various options have been provided to you and the correct option with respect to this particular question is D, which is limited to the amount which is unpaid if any on the shares held by them. So what is the liability of the members in case a company is limited by shares? And the Companies Act under section 4, which is talking about the memorandum, mentions that in case of a company limited by shares, the liability of its members is limited to the amount unpaid if any on the shares held by them. So it is mentioning about that. So इसका मतलब क्या हो गया? कोई भी member है एक company जो कि limited by shares है तो उसकी liability उस company में कितनी होगी? Okay, so the liability basically is with respect to or to the extent of the amount which he has unpaid with respect to the shares he is holding. So say if he has already paid all the amount with respect to the shares he is holding, in that case his liability will be nil since there is no unpaid amount with respect to the shares he is holding. So in case all the amount has been paid and there is nothing which is unpaid with respect to his shares, the liability is nil. However, if there are certain amounts which have been unpaid on the shares he is holding, then his liability is to that particular extent, to the extent of the unpaid amount. Moving ahead with our second question, that is, a public company is a company which has a minimum paid up capital of what? So the various options are no minimum paid up capital requirement, 5 lakh rupees or 50 crore paid up capital, 1 lakh rupees or such higher paid up capital as may be prescribed, 5 lakh rupees or such higher paid up capital as may be prescribed, and none of the above. The correct option with respect to this question is A, which is no minimum paid up capital requirement is there. So section 2 clause 71, that is talking about what a public company is, basically defining it. So public company, it mentions, is a company which is not a private company, has a minimum paid up share capital as may be prescribed, and so basically there is, as of now, there is no prescribed amount and therefore there is, we can say, no minimum paid up capital requirement as of now with respect to a public company. So the correct option with respect to this is our option A. So moving on to our next question, the registrar shall allot a company corporate identity number which shall be. So basically what is a corporate identity number, which we can also refer to as SIN. So one of the questions can be what is a SIN. However, another can be the full form of SIN can also come. So it's corporate identity number. So you have been provided various options with respect to that and you have to be very careful when you are choosing the option, the correct option. Reason being, आप exam में देखोगे कि बहुत near options आते हैं, मतलब that they are very near or they are very confusing, you can say. So until and unless आपका concept बहुत clear है, you are thorough with it, the chances are you can get stuck with the options which are provided to you. Like in this particular question also, you can see the options are so near and confusing that if you are not clear with the concept, you might get stuck or you might make a mistake. Looking on to the very question, we can see the correct option with respect to this is A. What is a corporate identity number? It is a distinct identity for the company which shall also be included in the certificate of incorporation. So our option A, that is the correct option, जो कि हमारे section 7 में से related provision है, that is talking about incorporation of a company, and subsection 3 3 is talking about on and from the date mentioned in the certificate of incorporation, registrar shall allot to the company a corporate identity number. What is it then? It has been mentioned, which shall be a distinct identity for the company and which shall also be included in the certificate of incorporation. So we know there is a DIN also, that is director's identification number. Same way जैसा DIN होता है director से related identification number, in the same way there is SIN, that is corporate identity number. Okay, it's a distinct and unique identity which is given to the company by the registrar of companies when he is issuing the certificate of incorporation, and in that certificate of incorporation only that SIN number is basically included. So that is a provision related to that is provided under section 7. Now moving on to the next question, what is the minimum number of members required to form a public company? And there are various options which are provided, like no such prescribed number, minimum 2 members, minimum 7 members, minimum 17 members as the central government may prescribe. And the correct option with respect to this is C, which is minimum 7 members. So the minimum number of members which is required to form a public company is 7. So the provision with respect to this you can find in section 3, which is talking about formation of a company. A company may be formed for a lawful purpose. So lawful purpose के लिए company को बनाना है, that is there. 7 or more persons where the company to be formed is a public company. So if we talk about private company, 2 or more persons are required, and for OPC that is 1 person company, 1 person is required. Now moving on to the question number 5, as per the Companies Act, a private company means a company. So what is a public company? What is a private company? What is OPC? All these we have to be very clear with. So if we talk about what a private company is, various options have been given to us, and the correct option is A, which restricts the right to transfer its shares. So with respect to transfer of the shares in a private company, there are certain restrictions and they are contained in the Articles of Association of the company. So you can see section 2 clause 68 talks about private company. A private company is a company which is having a minimum paid up share capital as may be prescribed, and which by its article restricts the right to transfer its shares, except in case of 1 person company the number of members is limited to 200, and where 2 or more persons are holding 1 or more shares in a company jointly, then in that case they will be treated as a single member. So these are the various important things with respect to understanding what a private company is. Moving on to our next question, which of the following is incorrect with respect to the information that are required to be incorporated or contained in the Memorandum of Association of a company? So Memorandum of Association, what it is, Articles of Association, what it is, all these are the basic documents very important for the company, because one of it, that is Memorandum of Association, that basically dealing with or that is talking about the relationship of the company with the outside world. If we talk about the Articles of Association, that is basically related to the relationship of the company with its members, all the internal affairs, management, etc. Now ये जो particular question अगर हम उस पे focus करें तो यहाँ पूछ रहा है कि जो Memorandum of Association है उसमें what all things are required to be incorporated or stated, and you have been provided various options like the name of the company, the liability of the members of the company, objects for which the company is proposed to be incorporated, rules and regulations governing the internal management of the company, and none of the above. So which is incorrect? Correct with respect to the things that are required to be contained in the MOA of the company, and the correct option is D, that is the rules and regulations governing the internal management of the company, because this is with respect to the Articles of Association, and that is why this is incorrect. Rest all options are correct. Now section 4, that is talking about Memorandum of Association, that mentions memorandum of a company shall state what? The name of the company with the last word. Ab name of the company sif state karega, that is not mentioned. How the name has to be? With the word limited if it is a public limited company, or if it is a private company then with the word private limited. The state in which the registered office of the company is situated, so registered office related there has to be information. Objects for which the company is proposed to be incorporated, liability of the members भी वहाँ important है memorandum में mention करना, whether limited or unlimited. In case of a company having share capital, amount of share capital with which the company is to be registered, division of shares, etc. that has to be there. Then in case of 1 person company, the name of the person who in the event of death of the subscriber shall be the member of the company. Question number 7 talks about the articles of a company may be altered by. अब ये दो important documents हैं, Articles of Association and Memorandum of Association. So once these documents are formed, is the company in a position to alter these? So the Companies Act provides the provision that these important documents of the company, they can be altered if required. However, However, there are certain compliances provisions they have to be taken care of. So with respect to articles of association, there is a provision that articles of association can be altered. So the various options with respect to this question are by an ordinary resolution, by a special resolution, by board resolution, by approval of central government, and none of the above. And the correct option is B, which is a special resolution. Section 14 that talks about articles of association alteration. So subject to the provisions of this act and conditions contained in the memorandum, if any, a company may by a special resolution alter its articles, including alterations having the effect of conversion of a private company into a public company and public company into a private company. So by a special resolution, there can be alterations made in the articles of association of a company. However, the company when going ahead with that, usko ensure करना है कि जो भी alteration हो रहा है, that has to be in compliance or consonance with the provisions that are there in the act, that is the Companies Act, and in the memorandum. Because हमें पता है, अगर हम बात करें कि कौन सी सबसे important है, if we talk about the Companies Act, the Memorandum of Association, the Articles of Association, so हम देखेंगे कि जो Companies Act का provisions है, nothing can be there in these other two documents, that is the articles and memorandum, that is in conflict with the provisions that are contained in the Companies Act. So Companies Act is the first and foremost thing which has to be complied because it's the law with respect to the company's formation, functioning, etc. So पहले Companies Act के contradictory कुछ भी नहीं हो सकता इन दो documents में. Then is the Memorandum of Association, and then comes the Articles of Association, and then the contracts agreements entered by the company. Our next question is, a company registered under Section 8 of the Companies Act shall not alter the provisions of its memorandum or articles except with the previous approval of. So first of all, इस question में Section 8 companies होती क्या है आपको ये पता होना चाहिए. So Section 8 companies कौन सी companies हैं? You can write in the comment box of this particular video. Correct option with respect to this is central government. Section 8, that is formation of companies with charitable objects, etc. A company registered under this section shall not alter the provisions of its memorandum or articles except with the previous approval of the central government. Next question, that is question number 9, is talking about which of the following is a new type of company which was introduced by the Companies Act 2013, and the various options you can see, and the correct option with respect to this is C, which is one person company is a new concept which was introduced by the Companies Act 2013. It has been defined under Section 2, Clause 62 of the said Act as company which has only one person as a member. And the last question for today's discussion is, a small company is a company whose paid up capital and turnover shall. So basically जो definition of small company है, there has been a change with respect to that definition. So if we talk about a small company is a company whose paid up share capital and turnover shall. So you can see the options are exceed rupees 2 crores and rupees 10 crores, exceed rupees 4 crores and rupees 40 crores, not exceed rupees 2 crores and rupees 20 crores, not exceed rupees 4 crores and rupees 40 crores, be such as the company may decide from time to time. And the correct option with respect to this question is D, which is not exceed rupees 4 crores and rupees 40 crores. So this particular term small company that has been defined under section 2 clause 85. So यहाँ पे इसका definition दिया हुआ है कि a small company, it is a company which is other than a public company, and various other things have been contained with respect to that. But what our focus over here is with respect to the paid up capital and turnover, जिसमें actually जो definition में change आया है, it is with respect to paid up capital and turnover only. So you can find that the company specification of definitions details rules 2014, rule 2 that is talking about for the purpose of clause 1 and 2 of clause 85 of section 2, paid up capital and turnover of a small company shall not exceed rupees 4 crores and rupees 40 crores respectively. So this was our last question for today's discussion. So in my next videos, I'll be taking ahead with other chapters and mock tests related to those chapters. Do remember to subscribe to our channel and stay tuned and stay updated.